So you've been fired, or worse, the company you work for is not turning a profit, so there's a good chance you just might be laid off. In such cases, it's always best you be prepared, and part of being prepared means knowing what you are entitled to by law. If all this sounds foreign, leading labor attorney Obie Ferguson explains.
The employee ought to know that reasonable notice ought to be given on termination. Now, by a reasonable notice, I'm talking about a reasonable period of time that it would take them basically to find other employment. That obviously would depend on the seniority of the person, the status of the particular person in that particular job. You're also entitled to be paid what we call accrued vacation. You see, in other words, at the time of termination, you're entitled to what we call accrued vacation for the unexpired portion of the year.
Mr. Ferguson also shared a little something you employees should keep in mind when determining reasonable grounds for termination.
The breach of trust. If the employee breached the trust with the employer can terminate summarily without paying him a dime. Incompetence, you can be terminated for incompetence. Very rare, one act of incompetence would be sufficient to terminate. You have to show over a period that the person lacks the ability to adapt to what is required, and in that case you can terminate them. Gross insubordination, and I know it's used sometimes inappropriately, but really what you're talking about, gross insubordination, which goes right to the root of the contract. Insubordination is not grounds for termination. It's grounds for disciplinary action. Gross insubordination, because it goes right to the root of the relationship between the employer and the employee, and therefore the employer can terminate. Other conduct, sexual harassment on the job, if you're found to be using your position to solicit or induce staff so that they can get certain favors.
And what about the rights of the employer?
You are required to pay the employee in the same manner as they would if they were fully employed and the business is going normal. See, the ability to pay has nothing to do with an obligation to pay. You follow me? The fact that the company is not doing well, that has nothing to do with paying the worker. They're two separate things. Now, once you say that the company is going to close because of lack of business, you're really talking about redundancy there. That's quite obvious. Then you look at the law which governs redundancy. The law there says same thing, 2 weeks notice, 2 weeks VCF notice. Alternatively, you go to the 4 weeks, excuse me, the 4 weeks VCF notice.
So let's recap. 1. As an employee, you're entitled to be given reasonable notice of your termination and also the amount of pay for the time you've worked at the company. You are also entitled to vacation pay. 2. As an employee, you are fully protected by the Employment Act. And finally, as an employer, you have the right to terminate your employee, but the grounds for termination must be reasonable. I'm Sasha Lightbourne, and now you know your rights.